what they're trying to get us on. The fact that we call a legal expense. They marked it down in the books. The check was signed.
Sandra, at one point, testimony here got so graphic, the judge had to scold prosecutors. And yes, as you said, the defense demanded a mistrial. Well, the judge today refused to do that. But after nearly 2 weeks, we're finally getting to the heart of this case.
So Trump just got absolutely smacked down in federal court. And here's the wild part. It was his own judge who did it. Like a judge he personally appointed, looked at his legal argument and said, nope, this is completely untethered to reality. We're not doing this. The case is about Trump trying to send the National Guard into Portland, Oregon. And the judge shut it down so hard that even Trump's legal team has to be wondering what just happened. This is a major loss, like a really embarrassing courtroom defeat that puts a huge dent in Trump's law and order strategy. Let me explain what went down, because this is actually crazy. Trump wanted to federalize the Oregon National Guard and deploy them to Portland. Federalize means take control away from the state governor and put those troops under direct presidential command. Then send them into the city to deal with what Trump's calling left-wing violence and protests that are destroying American cities.
The drama in the courtroom at Donald Trump's hush money trial. Stormy Daniels, the adult film actress at the center of the case, took the stand and testified that she hates the former president and wants him held accountable. Daniels also described a sexual encounter with Trump. Mr. Trump's attorneys called for a mistrial.
His administration argued that Portland is basically a war zone, that local authorities can't or won't handle it, and that federal military intervention is necessary to restore order. Pretty dramatic stuff, right? But Judge Karen Emerget, and remember, she's a Trump appointee, she looked at the actual facts on the ground in Portland and said this is simply untethered to the facts. Those are her exact words, simply untethered to the facts. That's legal speak for you're making stuff up. The judge found that the protests Trump's talking about are small and uneventful, not some massive uprising, not a war zone, just normal protests that local police are handling just fine without federal troops. So Trump's entire justification for sending in the National Guard is based on a fantasy version of Portland that doesn't actually exist. The ruling came down on October 4th, late Saturday, and it's a temporary block while the case proceeds. But the judge's language is absolutely brutal. She warned about blurring the line between civil and military power. She cited the 10th Amendment and constitutional limits on presidential authority. She said the issues at stake are important and the consequences are far-reaching. Translation: this isn't just about Portland. This is about whether presidents can send troops into states whenever they feel like it, regardless of what's actually happening on the ground. And here's what makes this so significant.
Trump found himself no more than 25 feet away from her in a tense courtroom, where she described their meeting at a celebrity golf outing in 2006, a 27-year-old porn actress and a 60-year-old reality TV star. She testified it was Trump's bodyguard who invited her to his hotel suite.
Trump's been winning basically every major case at the Supreme Court, especially on immigration and executive power. We've talked about this pattern, right? Lower court says no, Supreme Court says yes, Trump wins. But this Portland case is different because even a Trump-appointed judge is saying, whoa, you've gone too far. This isn't an Obama judge or a Clinton judge who Trump can dismiss as biased. This is his own person telling him he doesn't have the authority to do what he's trying to do. Trump's legal team is furious. They're arguing that American cities are war-ravaged, that left-wing violence is out of control, that somebody needs to step in and restore law and order. And they're appealing to the Ninth Circuit, saying higher courts will back Trump's authority to protect federal assets and personnel, which, yeah, maybe they will. The Ninth Circuit is pretty liberal, so probably not. But if it gets to the Supreme Court, Trump might still win. That's been the pattern. But for now, this is an embarrassing loss. The White House is trying to downplay it, saying this is just one judge's opinion, and they're confident they'll prevail on appeal. But come on, are you kidding me? Your own appointee just said your legal argument is untethered to reality.
For most of his life, Donald Trump has sold himself as a successful businessman. He did it first as a minor New York celebrity, and then as a reality TV host, and then, however improbably, as a candidate for president of the United States.
That's not a minor procedural setback. That's a fundamental rejection of your entire theory of the case. Judge Emerget didn't say, well, there are some concerns, but we'll let it proceed with conditions. She said, no, you can't do this. The factual basis doesn't exist, and you're trying to blur constitutional lines that shouldn't be blurred. What's really interesting is the timing. This comes right in the middle of the government shutdown, right as Trump's testing all these different executive power moves, right as multiple courts are reviewing his aggressive assertions of presidential authority. And now one of his own judges is pumping the brakes, saying, hold on, there are limits. Even judges who generally support Trump's agenda are saying you can't just make up emergencies to justify military deployments into states that don't want federal troops. Portland's mayor and Oregon's governor are celebrating, obviously. They've been saying all along that Trump's characterization of the city is completely false. Portland has protests, sure, but it's not some anarchist hellscape. It's a functioning city where people live and work and go about their lives. Trump's been painting this picture of burning buildings and lawlessness to justify federal intervention, but when a judge actually looks at the evidence, it doesn't hold up. The protests Trump's talking about are small, mostly peaceful, and being managed by local authorities without any need for National Guard troops. So where does this leave Trump's law and order strategy? Well, kind of in shambles at the moment. He wanted to make a big show of force, send troops into liberal cities, look tough on crime and chaos. But the courts are saying you can't just deploy military force based on exaggerated claims about what's happening. You need actual evidence of an emergency that local authorities can't handle. And right now, that evidence doesn't exist. This is a rare loss for Trump in a legal fight he probably thought would be easy to win. Okay, so let's dig into what actually happened here, because there's a lot of constitutional law and executive power stuff that makes this case really important beyond just Portland. The legal framework for federalizing National Guard troops is actually pretty specific. The Insurrection Act is the main law that gives presidents this power, but it requires certain conditions to be met. You need to have domestic violence or conspiracy that makes it impracticable to enforce federal law through normal judicial proceedings. Basically, there has to be a real emergency where local authorities genuinely can't maintain order. Trump's argument was that Portland meets that standard. His lawyer submitted declarations saying the city is experiencing ongoing violence.
And the judge ordered the dissolution of Trump's businesses in the state of New York. Here's what he wrote. Ordered that any certificates filed by any of the entity defendants or by any other entity controlled or beneficially owned by Donald J. Trump, Donald Trump Jr., Eric Trump, former Trump Organization CFO Alan Weisselberg, and Trump Organization controller Jeffrey McConney are canceled.
That federal buildings are under threat, that local police aren't adequately protecting federal property and personnel. They painted a picture of chaos and disorder requiring federal military intervention. And look, Portland has had protests, especially during the shutdown and around immigration enforcement. But the question is whether those protests rise to the level where you need to federalize the National Guard and send in troops. Judge Emergut looked at the actual evidence and said absolutely not. She reviewed reports from local police. She looked at incident data. She examined what's actually happening on the ground. And what she found is that the protests Trump's team is describing are small and uneventful. There might be a few dozen people gathering to protest, maybe some chanting and signs, but nothing violent, no attacks on federal buildings, no riots, no breakdown of civil order. Local police are present, monitoring the situation and handling any issues that arise. There's no emergency. The judge's opinion is really worth reading because she methodically dismantles Trump's factual claims. She points out specific instances where the administration's declarations exaggerated or mischaracterized what happened. For example, Trump's team cited a protest where they claim hundreds of violent demonstrators attacked a federal courthouse. The judge looked at the police reports and surveillance footage and found it was maybe 50 people, mostly peaceful, with a couple individuals who got rowdy and were immediately arrested by local police. That's not an insurrection. That's a Tuesday in any major city. So when Judge Emergut says Trump's justification is simply untethered to the facts, she's not being hyperbolic. She's saying the administration made factual claims that are demonstrably false, and you can't deploy military force based on false claims. That's not how the Insurrection Act works. You need a genuine emergency backed by real evidence. Making up an emergency to justify the deployment doesn't cut it. Now, Trump's defenders would argue that the judge is being too technical, that presidents need flexibility to respond to threats, that waiting for a situation to get worse before acting is irresponsible. They say Trump's trying to prevent violence before it escalates, and judges shouldn't second-guess presidential judgment about national security. Fair enough as a general principle, but the problem is Trump's not claiming there's a potential future emergency. He's claiming there's a current emergency, and the evidence shows there isn't. The constitutional issues here are really significant. The 10th Amendment reserves powers to the states that aren't specifically given to the federal government. One of those powers is controlling law enforcement within state borders.
Is a fairly staggering development for the man whose entire reputation was built on his alleged business acumen. It is also not all that this judge has decided. Because of this order, several of the crown jewels in Trump's real estate empire, the properties upon which he built his brand.
Governors command their state's National Guard. Presidents can federalize the Guard, but only under specific circumstances defined by Congress. This is a fundamental part of federalism. the balance between state and federal authority. If presidents could federalize guard troops whenever they want, based on exaggerated claims about local conditions, that would completely undermine state sovereignty. Judge Emerga emphasized this point. She warned against blurring the line between civil and military power. That's a reference to the Posse Comitatus Act, which generally prohibits using military forces for domestic law enforcement. There are exceptions like the Insurrection Act, but those exceptions are meant to be narrow. Using the military for normal law enforcement is something we don't do in America. It's what happens in authoritarian countries. So when Trump tries to send National Guard troops to handle protests that local police are managing fine, he's crossing a line that has historically been pretty sacred. The timing of this ruling is also interesting because it comes right after we've been talking about Trump's Supreme Court winning streak on executive power. Trump's won on immigration raids, on TPS terminations, on all these other assertions of broad presidential authority. So why is he losing this one? Part of it is probably that even sympathetic judges have limits. Even judges who generally defer to executive power on immigration or national security can look at a case where the president is making obviously false factual claims and say, nope, that's too far. And Judge Emerga is a Trump appointee, which makes this sting more. She's not some liberal activist judge with an axe to grind. She's someone Trump's team presumably vetted and thought would be sympathetic to his agenda, but she looked at this case and her judicial integrity required her to call out the falsehoods. That's actually kind of reassuring from a rule of law perspective. It suggests that at least some judges Trump appointed take their constitutional duties seriously enough to rule against him when the facts and law require it. The White House response has been to dismiss this as one judge's opinion that will be overturned on appeal. They're already preparing their Ninth Circuit brief, and they might be right that higher courts could reverse this. The Ninth Circuit is pretty liberal, so they'll probably uphold Judge Emerga's ruling, but if it gets to the Supreme Court, who knows? The conservative majority has been so deferential to Trump on executive power that they might find a way to let him do this. But there's also a chance the Supreme Court doesn't want to touch this case because ruling for Trump will require them to either accept obviously false factual premises or say that presidents can federalize troops even when the factual justification is bogus. Neither of those is a good precedent to set. The court might prefer to just deny cert and let the lower court ruling stand, avoiding a messy confrontation over presidential power and state sovereignty. Meanwhile, Portland officials are making the most of this victory. The mayor held a press conference saying this vindicates what they've been saying all along, that Trump's characterization of the city is false and politically motivated. Oregon's governor said federal troops aren't needed or wanted, that the state can handle its own law enforcement, and that Trump should focus on actual national emergencies instead of manufacturing fake ones in liberal cities. And that gets to the political dimension of this. Trump's law and order strategy has been to paint democratic cities as violent hellscapes that need federal intervention. It's both a campaign message and a governance strategy.
And the judge here, Judge Arthur Engeron, made very clear what he thought of the defense, also, again, as part of his ruling. The judge accused the defense of living in a fantasy world, not the real world. He accused the defense of obstreperous conduct and reliance on bogus arguments and intentional and blatant disregard of controlling authority and law of the case.
By sending troops to cities like Portland, he signals to his base that he's tough on crime and liberal chaos, but it only works if people believe the cities actually are violent hellscapes. When judges start pointing out that the emperor has no clothes, that the claimed violence doesn't exist, it undermines the whole narrative. This isn't just about Portland. Trump has made similar threats about other cities, Chicago, Seattle, San Francisco, all the usual suspects. He's been saying these cities need federal intervention because local Democratic leadership has let them descend into anarchy. But if courts are going to fact-check those claims and reject military deployments based on exaggerated or false characterizations, that limits Trump's ability to execute this strategy. The legal arguments in the case are also interesting from a separation of powers perspective. Trump's lawyers argue that decisions about federalizing the National Guard are committed to presidential discretion and courts shouldn't interfere. It's a political question that judges should stay out of. But Judge Emerga rejected that argument. She said courts absolutely have a role in reviewing whether the factual predicate for invoking the Insurrection Act exists. Presidents don't get to make unreviewable claims that an emergency exists when the facts show otherwise. That's actually a pretty important ruling for executive power generally, because if Trump could invoke the Insurrection Act based on false claims and courts couldn't review it, that would give presidents essentially unlimited power to send troops wherever they want, just claim there's violence and disorder, deploy the military, and tell courts to stay out of it. Judge Emerga is saying no. Courts can and should review the factual basis for these claims. Presidential power isn't unlimited. Military.com covered how this ruling is being received in military circles, and apparently there's some relief. Military leaders generally don't want to be used for domestic law enforcement. It's not what they're trained for. it puts troops in difficult situations, and it risks politicizing the military. When presidents send troops to deal with protests, those troops can end up in confrontations with American citizens. That's not a position military leadership wants to be in. So even though they follow lawful orders, there's probably some quiet satisfaction that the courts are limiting when those orders can be issued. The protest dynamics are also worth understanding. Portland has a history of progressive activism and protests. It's not unique in that regard, but it's maybe more visible than some other cities. During Trump's first term, Portland became a flashpoint with federal agents being sent to protect courthouses during Black Lives Matter protests. That created intense confrontations and became a national story. Trump's clearly trying to recreate that dynamic, using Portland as a symbol of democratic failure on law and order. But this time, the courts aren't letting him do it based on false premises. All right, let's break this down into what it actually means going forward, because there are some really important implications here. Point number one, this shows that even Trump-appointed judges have lines they won't cross. We've gotten used to seeing Trump win basically every case at the Supreme Court, especially on executive power. But this Portland ruling reminds us that lower court judges, even once Trump appointed, still have judicial integrity. When the facts are so clearly against Trump's claims that ruling for him will require ignoring reality, some judges will rule against him. That's actually important for the rule of law. It suggests the judiciary hasn't been completely captured by partisan politics. Judge Emmergut could have found a way to defer to presidential judgment to say the emergency determination is unreviewable to let Trump do what he wants, but she didn't. She looked at the evidence, found it didn't support Trump's claims, and ruled accordingly. That takes courage, especially for a judge who might face criticism or political pressure for ruling against the president who appointed her.
It scolded prosecutors to curb their questioning. The degree of detail we're going into here is just unnecessary. Outside the presence of the jury, the defense demanded a mistrial. This has nothing to do with the reason why we're here, said Attorney Todd Blanche. How can you unring a bell? The judge denied the request, but added there are some things that would have been better left unsaid.
Now, does this mean Trump's going to start losing a bunch of cases? Probably not. This is still an outlier. Most of his executive power assertions are winning in court, especially at the Supreme Court level. But it does show that when the factual basis is obviously false, even sympathetic judges will push back. Trump can't just make up emergencies and expect every court to go along with it. Point two, this ruling limits Trump's ability to use federal military force in Democratic cities as a political strategy. The whole point of sending troops to Portland was to create a spectacle. Federal forces in the streets confronting protesters, showing strength and law and order, is good visuals for his base who believe liberal cities are descending into chaos. But if courts are going to fact-check whether the chaos actually exists and block deployments when it doesn't, that strategy becomes much harder to execute.
Is at the heart of this case. Trump's former attorney Michael Cohen will testify that he made the payment on orders from Trump, that he was reimbursed with checks from the Trump Organization, which buried the payment as a legal expense so as not to damage the 2016 campaign.
Trump can still talk about how terrible these cities are. He can still campaign on law and order themes. But actually deploying military force requires meeting legal standards. And Judge Emmergut's ruling shows that courts will enforce those standards when the facts are clear. Trump needs to actually demonstrate that local authorities can't handle the situation. Exaggerating normal protest activity into an insurrection doesn't cut it. This might force Trump to be more strategic about when and where he tries to federalize troops. If he's going to invoke the Insurrection Act, he needs situations where the violence and disorder are real and documented, not manufactured. That's a higher bar than just claiming cities are dangerous. It requires actual evidence that will survive judicial scrutiny. Point three, the appeals process is going to be really interesting. Trump's team is appealing to the Ninth Circuit, which is one of the most liberal circuit courts. They'll almost certainly uphold Judge Emmergut's ruling, or maybe even expand on it. So Trump will lose there too. Then the question becomes whether the Supreme Court takes the case, and that's where things get unpredictable. On one hand, the Supreme Court has been very deferential to Trump on executive power. They might see this as another opportunity to expand presidential authority, especially on matters touching national security and federal property protection. They could reverse the lower courts and say the president has broad discretion to federalize troops when he determines it's necessary. On the other hand, this case has some really bad facts for Trump. The judge found his claims were simply untethered to reality. That's not a close call on disputed facts. That's a finding that Trump's team made stuff up. Does the Supreme Court want to rule that presidents can deploy military force based on false premises? That's a pretty extreme position, that could come back to haunt them with future presidents.
But the judge is clearly so angry about what he calls glaring misrepresentations. That's an embarrassing thing to receive as an attorney. You never want to have that associated with your name.
And fines of, I think, $7,500
against
apiece,
each of the people who signed on to the briefs that he said were.
My guess is the Supreme Court tries to avoid taking this case. They might let the Ninth Circuit ruling stand without review, or they might deny circuit on procedural grounds, because ruling either way creates problems. If they side with Trump, they're saying presidents can lie about domestic conditions to justify military deployments. If they side against Trump, they're putting limits on executive power that conflict with their general pattern of deferring to the president. Easier to just not take the case. Point 4. This has huge implications for state versus federal power dynamics. Governors control their state National Guard units. That's a fundamental aspect of federalism. Presidents can federalize the Guard, but historically, that's been rare and reserved for genuine emergencies like natural disasters or actual insurrections.
The judge says none of that actually matters for purposes of just the plain vanilla fraud case.
Yeah.
You don't need any of that. Now, he may need it for some of the other claims that are actually going to trial on Monday. But as for just that, all you needed was that there were false representations, and that's it.
If Trump could federalize troops whenever he wants by exaggerating local conditions, that would fundamentally shift the balance of power toward the federal government and away from states. Republican governors in red states should actually be worried about this. Because right now Trump's targeting blue states with Democratic governors, but the precedent he's trying to set would apply to all states. Future Democratic presidents could use the same authority to federalize Guard troops in Republican states. If the principle becomes that presidents can override governors on Guard deployment based on claims about domestic disorder, that cuts both ways politically. Judge Amurga's emphasis on the 10th Amendment and state sovereignty is important here. She's saying there are constitutional limits on federal power, that states have rights that can't be trampled just because a president wants to make a political point. That's a conservative legal principle that should appeal to judges who care about federalism. The Supreme Court's conservatives are often defenders of state authority against federal overreach. This case puts that principle to the test. The political fallout is still developing. Democrats are obviously celebrating this as a check on Trump's authoritarian tendencies. They're pointing to it as evidence that courts can still constrain presidential excess. Republicans are mostly downplaying it, saying it's one liberal judge's opinion that will be overturned. Trump himself has been relatively quiet, probably because criticizing a judge he appointed doesn't play well. But behind the scenes, this has to be frustrating for Trump's team. They've gotten so used to winning these executive power fights that a loss like this, especially from their own appointee, has to sting. It suggests their legal theories aren't as bulletproof as they thought. It shows that even sympathetic judges have limits on how far they'll defer to presidential claims. Looking ahead, Trump has a few options. He can pursue the appeal and hope higher courts reverse. He can try to federalize troops in a different city where the facts are stronger, though finding a genuine insurrection-level emergency is hard. He can shift strategy and use other federal law enforcement tools that don't require federalizing the Guard, or he can just use the attempted deployment for political messaging, claiming activist judges are blocking him from restoring law and order. My prediction is he does a combination of the last two. He'll keep the legal fight going because it generates headlines and lets him criticize judges, but he'll also shift to using federal marshals, FBI, DEA, and other agencies that don't require court approval for domestic operations. Those agencies can conduct operations in cities without needing to federalize state troops. It's not as dramatic visually, but it accomplishes some of the same law enforcement goals. The bigger picture here is about the limits of executive power.
It's a great point because in this case, you think of a normal trial who are, the victims. The banks in this case, the loans actually performed.
Right.
So they're not,
That was the case Trump was making.
Right.
Nobody lost any money. What's the problem
they
here?
all did well. It doesn't matter.
For most of Trump's second term, we've been seeing those limits get pushed further and further, with courts generally approving. But this Portland case shows there are still boundaries. When the factual basis for action is provably false, when the constitutional concerns are clear, even Trump-friendly judges will say no. That's reassuring for people worried about unchecked presidential power. But it's also just one case. Trump's still winning the vast majority of his legal fights. The Supreme Court is still giving him broad authority on immigration, on agency actions, on emergency powers. This Portland ruling is an exception, not a new trend. Trump can still do most of what he wants. He just can't deploy military force to cities based on made-up emergencies, at least not without better fact development. So where does this leave us? Trump suffered an embarrassing courtroom defeat from his own appointee. His law and order strategy for Portland is blocked, at least temporarily. The appeals could reverse that, but the Ninth Circuit probably won't, and the Supreme Court might avoid the case entirely. In the meantime, Trump's credibility on characterizing city violence takes a hit because a federal judge fact-checked his claims and found them false. For Democrats and civil liberties advocates, this is a rare win in a losing streak. It shows courts can still check executive overreach when the facts are clear enough. For Trump and Republicans, it's a setback, but not a catastrophic one. They'll appeal, they'll campaign on judicial activism, and they'll find other ways to execute their law and order agenda. The fight over presidential power and state sovereignty continues. Next time, we're going to look at what Trump's doing in Chicago, where he actually did send federal forces and courts haven't blocked it yet because the Portland case is about what Trump can't do. But there's a whole other story about what he is doing in other cities and whether those operations are legal or effective. The law and order strategy isn't dead. It's just hitting some legal speed bumps. And we need to understand both the successful deployments and the blocked ones to get the full picture of Trump's domestic security agenda.